Good morning, Your Honor. We're here in case 25-CR-1402, State of Ohio versus Carla M. Verona. Present in court is the defendant, who is accompanied by her attorney, Ms. Mary Catherine Corrigan. We are here today for a change of plea hearing. It is the state's understanding that the defendant is prepared to withdraw her previously entered plea of not guilty and enter a plea of guilty to count 1, tampering with evidence, a felony of the 3rd degree, along with the attached firearm specification for 1 year. The state would move to dismiss the remaining count 2 at the time of sentencing. There is no agreement with regard to sentencing, and prison is mandatory in this case. Thank you.
Thank you. Ms. Corrigan, does that all sound accurate?
It does, Your Honor. Thank you.
And Ms. Verona, were you able to hear what the prosecutor and your lawyer just had to say regarding what they believe your intentions are here today?
Yes, I do, Your Honor.
Now, you can be seated at this time, both of you.
Okay.
I don't interpret that as any disrespect. It takes a little bit of time. It's easier to be sitting down when we go through everything here.
Thank you.
But you're able to hear what was said?
Yes, Your Honor.
They indicated to court they believe it's your intention to withdraw your previously entered plea of not guilty to count 1 specification. Count 2 would get dismissed. We would defer sentencing to get some reports completed, come back on a future date for sentencing. Where there's no agreement between the parties regarding any recommendations for sentencing, each side is free to recommend to the court whatever sentence they feel is the right thing to do. Is that your understanding of the discussions that took place between your lawyer and the prosecutor, and more importantly, what you want to do today?
Yes, Your Honor.
Well, before I can accept your plea, I need to make sure you understand everything going on here. I need to make sure you understand what it is you're charged with and pleading guilty to, the rights you have that you give up by pleading guilty, as well as all the possible penalties you face. So for me to determine those issues, I will ask you a series of questions. If at any point when I'm asking you the questions, if you're unsure or unclear of anything I'm asking you, if you need anything repeated or clarified, if you want a moment to talk with your lawyer to ask her questions, or even if you want to ask me questions, make sure you let me know that, because I need to make sure you understand everything we're doing, all right?
Absolutely.
All right. Let's get started then. How old are you?
I am 48 years old, Your Honor.
Are you able to read and write the English language?
Yes, I am, Your Honor.
Any difficulty with that or difficulty understanding what you read in the English language?
No.
Are you a U.S. citizen?
Yes, I am.
Now, before coming into court here today, have you had any drugs or alcohol of any kind?
No, Your Honor.
What about in the last 48 hours?
No.
Not even prescribed medication?
Yes,
Nothing?
Your Honor. I am prescribed medication.
What prescribed medication would you have taken within the last couple of days?
I am on Lexapro. I am on hydroxyzine. I am on Prozocin. And then just stuff for my back. And that's it. What is the stuff for your back?
The stuff for your back, is
I'm
that
on
like a...
Roboxin.
Mm-hmm.
It's called Roboxin. And then I don't remember what it's called for my stomach for acid reflux.
Okay. So, in the paperwork I have, on the second page it reads, I'm not under the influence of any drugs or alcohol. I'm not taking any drugs or alcohol in a 48-hour period preceding this hearing. And I added, except for Lexapro, hydroxyzine, Prozocin, Roboxin, and acid reflux medication.
Yes, correct.
That sound accurate?
Yes, sure.
Now, any of those medications that I just listed that you've taken within the last couple days, do they in any way affect your ability to understand or appreciate where you are, what's going on around you, to communicate, anything?
If anything, they help me, right?
Okay. So no negative impact or influence because of these medications?
No, not at all.
Now, you would have been served with a copy of this indictment back in very end of October. That's the document, maybe beginning of November. The document that sets forth the charges you're accused of committing. Do you remember getting that?
Yes, I do.
And at some point you had the chance to look that over?
Yes, Your Honor.
Now, in that indictment, you are charged with 2 counts. You're pleading guilty to the first count, so I'm going to review that with you. If you have any questions, make sure you ask. But what's alleged here in count 1 and what you're admitting to is on or about September 15th, 2025 and or September 16th, 2025 in Willoughby Lake County, Ohio, that you, knowing that an official proceeding or investigation was in progress or was about to be or likely to be instituted, that you altered, destroyed, concealed, or removed any record, document, or thing with purpose to impair its value or availability as evidence in such proceeding or investigation. That conduct constitutes the offense of tampering with evidence. It's a felony of the 3rd degree. Do you understand what you're charged with and pleading guilty to in count 1?
I do, Your Honor.
Any questions about it?
No.
Now, there's also a firearm specification attached to this count that alleges that you had a firearm on or about your person or under your control while you committed the offense of tampering with evidence. Understand what's alleged in that specification?
I do.
Any questions about it?
No, Your Honor.
Now, there's a second count of this indictment of obstructing justice. It's a felony of third degree. That's being dismissed pursuant to the agreement. Is that your understanding?
It is, Your Honor.
Any questions about that charge?
I do not.
Well, then before I can accept your plea of guilty to count one that I just read to you, I need to make sure you understand all the rights you're giving up by pleading guilty. And you, first of all, have the right to have a trial. And the trial could be me as a judge, where I would listen to all the evidence and I'd make that decision whether you're guilty or not guilty. But you also have a constitutional right to have a jury trial. A jury trial would be in front of 12 citizens here from Lake County who would listen to all the evidence each side wanted to present. The jurors would consider and weigh all that evidence, and then those jurors would make that ultimate decision. And that ultimate decision reached by the jurors would have to be unanimous. Unanimous means all 12 of them would have to agree together, one way or the other, as each separate charge, whether you're guilty or not guilty. Do you understand that?
Yeah, I do.
Do you understand by pleading guilty you're giving up your right to have a trial?
Yes, Your Honor.
Now, if we had a trial, you would have the right to have an attorney represent you at that trial. If you cannot afford an attorney, the court would appoint one for you free of charge to do that. Do you understand that?
I do.
Excuse me. Now, at a trial, the prosecutor here would be representing the state of Ohio, and she would have what we refer to as the burden of proof. With her having the burden of proof, what that actually means is that it is her job, or she bears the responsibility or the obligation of proving you guilty at a trial before you could ever be found guilty. You're presumed innocent of the charges, and the presumption of innocence sticks with you and remains with you until the state, if at all, was ever able at a trial to overcome that presumption and prove you guilty. Do you understand that?
Yes, Your Honor.
Now, when I speak of this burden of proof, since this is a criminal case, that burden is what we refer to as proof beyond a reasonable doubt. Highest burden of proof we have in our justice system. And what it means, it's the amount of the evidence and the quality of that evidence the state would have to present at a trial to prove you guilty. So in this case, the state would have to present evidence to prove each element or each part of the charge beyond any reasonable doubt before you could ever be found guilty of this charge or specification at a trial. Do you understand that?
Mm-hmm. Yes, Your Honor.
You understand by pleading guilty, you're giving up your right to make the prosecutor prove you guilty beyond a reasonable doubt at a trial?
Yes, Your Honor.
Now, in order to do that, or at least in order to try to do that, prosecutor would bring witnesses into the courtroom to testify for the state by answering questions from the prosecutor. Once those witnesses answered the prosecutor's questions, then your lawyer would have the right on your behalf to ask those same persons questions. That's called cross-examination. She could ask him anything she wanted to within certain rules. Do you understand that?
Yes, Your Honor.
Do you understand by pleading guilty you're giving up your right to cross-examine or confront those witnesses that would come in here and testify against you?
I do.
Now, you'd also have the right at a trial. You can call your own witnesses to come to court to testify for you if you wanted to and answer your lawyer's questions. Now, you don't have to do that. You're not required to do that. But you have a right to do that if you want to. Do you understand that?
Yes, Your Honor.
And you further can request this court issue an order. We call that order a subpoena. What a subpoena would actually do is it would force or make someone come to court to testify for you and answer your lawyer's questions if they weren't willing to come in voluntarily on their own. Do you understand that?
Yes, Your Honor.
Do you realize you're giving up that right?
I do.
Now, you'd also have the right at a trial. You could choose to testify on your own behalf if you wanted to, but you do have a constitutional right not to testify if you don't want to. That's a decision or a choice that you would have to make. Do you understand that?
Yes.
And since that's your choice, what that really means then is that nobody else could force you or make you, nobody could compel you to testify against yourself at a trial if you didn't want to. I can't make you testify. But more importantly, the prosecutor is not allowed to call you as a witness and make you get up on the stand and force you to answer questions and testify. Your own lawyer can't make you testify if you didn't want to. Do you understand that?
Okay.
Further understand that if we went to trial and you were found guilty, you would have the right to appeal or challenge that guilty finding to a higher court, a court that sits above me and reviews my decisions. By pleading guilty here today, you're giving up or waiving any right you have to appeal a guilty finding. This court will enter if your plea is accepted, as well as any other issues you could have raised or brought to my attention up to this time. You understand that?
Yes, Your Honor.
All right, well, do you have any questions at all from me regarding any of these rights we've just discussed? These are all the rights you have and all the rights you're giving up by pleading guilty. Any questions?
No, Your Honor, I do not.
Do you understand them all?
Yes, Your Honor.
Do you still want to plead guilty?
I do.
Do Do you understand a guilty plea is a complete admission of guilt? It means you're admitting to the facts being alleged by the prosecutor. We're not going to argue later you didn't do it or it's someone else's fault or anything like that. Do you understand that?
Yes.
Further, as a result of pleading guilty, the effect of the guilty plea is that you'll be found guilty by the court.
Yes.
And then you will subsequently, on another day, be sentenced by the court. Do you understand that?
Yes, Your Honor.
Now, as far as sentencing goes, you're pleading guilty to a felony of the 3rd degree. This offense is punishable by a term in prison of a minimum of 9 months, a maximum of 36 months, or increments in between of either 12, 18, 24, or 30. So at the time of sentencing, so I'll select one of those numbers, 9, 12, 18, 24, 30, or 36, and that would be the number of months in prison you'd have to serve for the tampering with evidence charge. You understand that?
Yes, Your Honor.
Now, the charge also has what we call a firearm specification that's attached to it. This firearm specification requires the court impose a mandatory prison term of 1 year that has to be served prior to and consecutive to whatever prison sentence I impose on the tampering with evidence, the 9, 12, 18, 24, 30, or 36 months.
Yes, Your Honor.
So you serve the 1 year first, and then you would serve whatever the prison term is on the tampering with evidence. So they have to be served consecutively, which means one after the other. You understand that?
Yes.
I do not have the ability, if you've heard the term concurrent before, concurrent means sentences are run together at the same time. I'm not allowed, I don't have the authority to run the firearm specification, the prison term for the tampering charge concurrent. They have to be consecutive. Do you understand
Okay.
that? Any questions about that?
No.
Okay. And in as much as the firearm specification requires a mandatory prison sentence, that means I'm required to impose a prison sentence on the tampering with evidence charge as well, the 9 to 36 month range I mentioned. You understand that?
I do.
Now, are you currently on probation or parole to any other courts or agencies?
I am not, Your Honor.
Do you have any other criminal charges pending against you anywhere?
I do not.
Your Honor, I don't think she does. She does have quite a checkered criminal history and does have some substance abuse issues, and she doesn't believe she does. We don't know of it. We don't.
Fair enough.
I just want to.
I'll explain the reason I'm asking. It's nothing more than if you have a pending charge against you, felony charge, and you're sentenced to prison on that other case before you're sentenced on this case, I could run. I'd have to run consecutive. This firearm specification has to be consecutive to anything else.
Okay.
But that's only if you're sentenced to prison before you come back here for sentencing.
Yeah.
Doubt that's happening because you're not going to get out here. It doesn't appear to that's the case to go anywhere else.
Yeah, Your Honor, I don't believe.
Okay, well, that's the only reason I'm telling you that.
Yeah,
If you're
thank
sentenced
you.
to prison before you're sentenced here, I could run my prison term consecutive to that. That's the
Okay.
only reason I'm asking that.
Sorry.
I can't run it, concurrent or consecutive to some possible future unknown sentence. It's already got to be imposed.
Yeah, I honestly, Your Honor, as far as I know, I don't have anything.
It's fine. That's the reason I was asking. The only reason I was asking.
I've done everything in my possible ability when I fall down and if I fall down to get myself back into either a psych ward or any type of treatment. I never thought I'd be back in front of a judge again, Your Honor, so.
Were you? I may have asked you this, and if I did, I'll ask it again because I can't remember if I asked. Were you on probation or parole or post-release control to any other courts or agencies when this happened?
No.
Now, if a prison term is imposed in this case, upon your release from prison, you could be placed on what is called post-release control, sometimes referred to as parole. It's a period of supervision you would be on after you completed the prison sentence, and it could be, in this case, up to 2 years. You understand that?
Yes, Your Honor.
And if you're on post-release control and you were violating any of the conditions of your supervision, the parole authority can return you to prison as punishment for violating their rules for another 9 months for each violation you commit, up to an overall maximum of 50% or half of whatever the prison term was imposed by the court. Do you understand that?
Yes, Your Honor.
Now, aside from the possible prison or the mandatory prison sentence I just mentioned, there's other sanctions that could be ordered. You could be fined in this case up to $10,000. You could be ordered to pay court costs. You could also be ordered to reimburse the county for any costs of confinement, community supervision, or treatment if any of that were applicable. Do you understand that?
Yes, Your Honor.
Now, a few moments ago, I was explaining the prison sentences, the possible prison sentences, and I told you it was mandatory, though, that prison had to be imposed. That means you are not eligible for probation, what's called community control sanctions. Do you understand that?
Yes, Your Honor.
Now, while you're not eligible for community control sanctions here at the time of sentencing, after you have served any mandatory prison term that would be imposed in this case it would be the 1 year for the firearm specification, you would be eligible at some point to request judicial release, which is a motion you could file with the court requesting to be released and put on community control sanctions. Now, you're not entitled to it, and it's not guaranteed you would get it, but you could request it after you serve some period of time after the mandatory prison sentence. You understand that?
Okay, thank you.
Lastly, when we come back here for sentencing, you'll have the right at that time to say anything you want me to know or consider.
Sure.
Your lawyer could speak on your behalf, recommend the sentence to the court. The prosecutor can also recommend the sentence to the court. Do you understand that?
Yes, Your Honor, thank you.
Do you understand that whatever the lawyers say at the time of sentencing regarding what they think the sentence should be, it is just what I said. It's a recommendation. I don't have to follow that if I didn't think it was the right thing to do. Do you understand that?
Yes, Your Honor.
All right, well, do you have any questions at all about the potential penalties you face by pleading guilty?
I do not,
You
Your
understand all the possible consequences?
Honor. I do.
Do you still want to plead guilty?
Yes, Your Honor.
Have you had enough time to discuss this case with your lawyer and have her review the reports with you, discuss issues, answer whatever questions you may have?
I have.
Are you satisfied with the advice and counsel of your lawyer?
I am. Yes.
Has she or has anyone else made any promises to you about what's going to happen at sentencing, which is inducing you to plead guilty?
No, Your Honor.
Have you been threatened or coerced in any way to plead guilty?
No.
Are you entering the plea freely and voluntarily?
Yes.
All right, any questions for me then at this time regarding anything we've talked about, the rights you're giving up, the penalties you face, what you're pleading guilty to? Any questions?
I do not, Your Honor.
You still want to plead guilty?
Yes, Your Honor.
All right, then what's going to happen at this point, the prosecutor here is going to explain for me what she believes the facts would show if we had a trial. I want you to listen to what she says, because then I'm going to have some follow-up questions for you, all right?
Yes, Your Honor.
All right. Ms. Timmerline?
Thank you, Your Honor. Had this matter proceeded to trial, the state would establish beyond a reasonable doubt that on September 15th, 2025, there was a shooting that took place at Fox Run Apartments in the city of Willoughby, Lake County, Ohio, where DeMonte Perry was shot and later died. The defendant was interviewed by the Willoughby Police Department, where she admitted that she was aware of the shooting that occurred at Fox Run on September 15th, 2025, and that her son, Christopher Ferrona, had called her sometime after it happened. Christopher Ferrona told her that he was in trouble, and she told him that she was coming down there. Christopher Ferrona told the defendant that he had the gun. The defendant admitted to the Willoughby Police Department that she retrieved the gun from the bushes at Fox Run Apartments, again located in Willoughby, Lake County, Ohio, in order to assist Christopher Ferrona. She took the firearm and gave it to a drug dealer in Cleveland. The Willoughby Police Department was able to recover the firearm from that person, and were able to confirm that the same firearm was used in the shooting on September 15th, 2025. Thank you.
Thank you. Ms. Ferrona, were you able to hear what the prosecutor had to say regarding what she believes the evidence would show if we had a trial?
Yes, I have.
What, if anything, do you have to say about those facts as she presented them? Are they true? Did you do what she said?
Okay, Your Honor, to a degree. When my son called me, I didn't go into where he was. We called Melvin Harris. I did go as close as I could. I did not go in. My son told me the gun...
You did not go in where?
To the apartment.
To the apartment where it had happened. The next day, my child had my food card. This can all be proven.
I want to know if you tampered with this gun, which was evidence in a proceeding.
He wants to know, did you go and retrieve the gun
I
from
did,
the
Your
bushes?
Honor. Afterwards, yes.
Knowing that it was potentially evidence in a criminal
I
investigation?
did. Yes, Your Honor.
And you possessed it when you got it?
Yes, I did.
Right. Anything else you'll be able to explain to the probation department. I just
Okay.
want to find out whether you are admitting to the specific elements of the offense that you...
Okay, I didn't know if you wanted to know exactly what had happened.
You're going to get a chance, you're going to go to the probation department and meet with them and give them your own version twice of what happened. You can talk to them orally and have an oral interview with them, and you're also going to get a chance to write it out if you want.
Okay.
So you'll get that opportunity. I'll get a chance to look at it. So I'm not review that.
Thank you.
Not an opportunity. I will review it. So, but the point here is just that you're admitting to the specific elements of the charge,
Okay.
which is what you just said, that you got that gun
Yeah.
knowing that it was evidence in a criminal proceeding.
Yeah, I'm sorry, I was just a little confused.
That's all right.
Thank you.
Did you know that he had died at that point though?
I did not.
All right,
It
well,
doesn't, I don't think it changes
No, it doesn't
the
change
actual
that.
elements of the facts.
Yeah.
but I
Because it's just
totally-
that it's a criminal investigation
Yes.
that you knew was going
Correct.
on. You knew that, correct?
Yes,
Yeah, okay.
yes.
Very well then, regarding count 1, charging you with tampering with evidence of felony of the 3rd degree, what is your plea to that?
Guilty.
Regarding the 1-year firearm specification, what is your plea to that?
Guilty.
All right, I have in my possession at this time a 4-page document called a written plea of guilty and judgment entry, which explains everything I've just explained to you. Before I can accept your plea, I need to make sure you understand that document and that you sign it here in open court. Now, my understanding is before I came out here, you had a chance to go over that document with your lawyer. Is that correct?
Yes, Your Honor.
Ms. Corrigan, is that accurate? Did you review that with
I did,
Ms.
Judge.
Frona?
Yes.
Read it over with her?
Yes, sir.
Did she indicate an understanding of it to you when you did that?
She did, very much so.
Is that correct, Ms. Frona? So you understand the document?
Yes, Your Honor.
Any questions for me about what it says?
No, Your Honor.
It also appears you signed the document. Did you in fact sign it?
Yes.
You witnessed that, Ms. Corrigan?
I did.
And Ms. Simline, you as well?
Yes, Your Honor.
Very well, that at this time the court will accept the defendant's oral and written plea of guilty. Let the record reflect the defendant was here in open court with her lawyer, advised of all her constitutional rights, made a knowing, intelligent, and voluntary waiver of those rights. Court also finds the defendant understands the nature of the charge, the effect of the guilty plea, as well as the maximum penalty that can be imposed. Finding this to be knowing, intelligent, and voluntary, the court will accept the defendant's plea. Finding the defendant guilty of count 1, tampering with evidence, of felony of the 3rd degree in violation of 2921.12A1, along with the firearm specification. Count 2 will be dismissed. I'm going to defer sentencing, order a pre-sentence report and investigation, and I'll continue defendant's bond. Is there anything else for the record at this time, Ms. Himmeline?
Your Honor, can we get a victim impact statement as well?
Victim impact statement. Ms. Corrigan, anything else?
No, thank you, Judge.
Thank you.
All rise.
All right, I'll be in to see you. Depending on the weather, it might not be tomorrow, but.
That's fine.
Okay.
Thank you, Your Honor. It pleased the court, we're before the court this morning in the matter of the State of Ohio versus Martin Martinez, case number 25-CR-1102. The defendant is present in the courtroom with his attorney, Mr. John Fatica. We're before the court this morning for purposes of sentencing the defendant having pleaded guilty and been found guilty of 1 count theft and felony of the 5th degree. Parties are ready to go forward, Your Honor.
Thank you, Mr. Fatica. Any reason not to go forward with sentencing?
No, Your Honor.
Anything you want to say on behalf of your client?
Your Honor, I'd like to start off by saying that Mr. Martinez understands he used very poor judgment not to show for his PSR. He did turn himself in voluntarily. 34 years old. He's currently employed as a laborer for Deck Rescue. He has 6 children. The youngest of his children, both under 2 years of age, live with him and his fiancee. He has 16 days of jail credit as of today.
How many?
16.
16.
16.
I thought you said 60.
No.
Yeah.
We've submitted a number of letters that demonstrate that he has supportive family and friends. He's been active in AA. He's been a sponsor in the past. He relapsed here. And again, we understand that the court's options are limited, but we'd ask for leniency. Thank you.
Mr. Martinez, you have the right to address the court before you're sentenced. You can say anything you want. Is there anything you want to say at this time?
Yeah, I wanted to apologize to the victims. I know they're not here. Mike and Anna were very kind to me in my life and provided me with an opportunity when I was in early recovery several years ago. I don't know where things went wrong, and I don't have an excuse for what I did for them. And I hope I can make restitution and a personal amends to them. I'd also like to apologize to my family sitting over there. They've stood by my side for 20 years of addiction. And even with the good years, I know there's always that anxiety of the next relapse. And I just love you and thank you for always being there for me. I'd like to address to you, I'm sorry I didn't show up. I wasn't in my right mind. And I just want to put this behind me. That's it.
Mr. Fatica, anything else on behalf of the defense?
No, thank you, Your Honor.
Mr. DePiro for the state of Ohio.
Thank you, Your Honor. You know, Mr. and Mrs. Day are not here today, but I'll tell you, Mr. Day was here the last time we had a sentencing set in this matter. He sat in that hallway and he waited patiently to express to the court how the defendant's actions have hurt he himself and his wife and his business. The amount of restitution here is $6,006.07.
6006?
Yes. That's what we can show. That doesn't include the times that the defendant is seen on video reaching his hand into the shared tip jar and taking cash. That also doesn't additional conduct that the Days just simply didn't have time to scrutinize. The Days were very active and helpful in submitting documentation of the theft to the Mentor Police Department, Your Honor. And Mr. Day put together a spreadsheet that delineated every single time that the defendant stole from them. There's 188 entries in those months of time. And every single one, the Days looked at the video, documented it, wrote it down, so that we could prove that the defendant stole this money, which was not an easy task. And that took a lot of effort on their part. Over and above being victimized by the theft, they had to do all that. Mrs. Day confided in me that they had a prior incident with the defendant where he was stealing from them, but they gave them another chance because the Days know that the defendant has children to support and they did not want the defendant's children to suffer. And he just talked them into that he's a decent guy and that he should get another chance. Mrs. Day feels very strongly that that's not the case, that this is not a situation of a good guy with a drug problem. This is sustained criminal conduct that hurt them. and is worthy of incarceration and punishment. The defendant does have credit for 16 days. Thank you.
Thank you. This court has considered the facts and circumstances of the offense involved and nature of the offense. I don't have a pre-sentence report to consider because the defendant failed to appear at the probation department for his interview and for the preparation of the pre-sentence report, so one was not able to be completed. I did receive a victim impact statement, and I've read and considered what the victims have had to say. I received multiple letters in support of the defendant from family members, acquaintances, and I've read all of those and taken those into consideration. I've considered what's been said here today by the defendant himself, his lawyer, the prosecutor. All this is considered by the court and by the purposes and principles of felony sentencing set forth in 29-29-11. For the factors in 29-29-12, the court finds in regards to the factors that make the offense more or less serious. That the victims in this case not only suffered serious economic harm, but also emotional harm. They entrusted the defendant, and he violated that trust. The economic harm, as alluded to by the prosecutor, is not the only loss they had. They spent hours and hours putting stuff together and researching and investigating what happened here. The defendant's relationship with the victim facilitated the offense. The defendant had a position of trust with the victims in the business there and used that position of trust to commit this crime. No factors indicate that the offense is less serious than normal. This took place over a 7-month period of time. This wasn't just a one-time incident that occurred, which is what most offenses are. This was 7 months of planning and scheming. Every time money is taken, it's a crime itself. It's planned out and it's schemed, and the cover-up has to be involved. And he did this over and over and over, 180 some times, at minimum. And they trusted you. They helped you. They gave you advances on your pay every paycheck almost. Because you talked about how you were in financial need and dire straits, and you had kids to support. And they went out of their way to help you, and that's how you treated them. No factors, again, make this less serious. As for recidivism factors, the court notes that the defendant has a drug abuse problem. I don't know if it relates to the offense or not, but he hasn't done anything to address it. 20 years. I think one letter mentioned 18-year opioid addiction. He mentioned 20. He hasn't done anything to address it. He violated the conditions of his bond in using drugs while on bond and failing to appear for the probation department, failing to appear for his sentencing, even though he turned himself later in that day. He wasn't here for his sentencing. Factors indicating recidivism is less likely. The defendant doesn't have any criminal history. He's led a law-abiding life for a significant number of years. In terms of any convictions, he's been using drugs for 20 years. And obviously that's against the law, but he hasn't been convicted of any offenses with that. The problem here is that you didn't show up for your pre-sentence report. And you were specifically advised when we were here last time that in order to be considered for probation, a pre-sentence investigation had to be completed. And in order for a pre-sentence investigation to be completed, an interview with you had to take place. And you were specifically told if you fail to show up for that interview, probation cannot complete a report, and the court doesn't even have the lawful authority to put you on probation. And you were also told that if you, the court will not continue the sentencing to some later day to get the report done because it wasn't completed initially due to your lack of cooperation. And you even mentioned about how you had used shortly before that. And I specifically even told you, I watched the video before I came out here at the last hearing. I go, even if you're afraid of being arrested, you need to show up. It's important to show up no matter what. And you didn't show up. So I can't put you on probation. I don't have the authority to do it. And you were specifically told that. And you made that conscious decision not to do it, not to come in. And even in this case, you were supposed to show up on December 22nd. You didn't show up to probation. They contacted you and they spoke to you. And they rescheduled it after the holiday. Because if you would have gone on the 22nd, you would have been arrested. Wouldn't have been able to spend the holiday with your kids. But they let you then give you another week. To December 29th. So if there was a warrant out for you, you could have been home with your kids for the holiday and still gotten your pre-sentence report done. Now, they didn't ask me about that beforehand. I don't know if I would have allowed it, but they allowed it. And you didn't show up on December 29th. So when you talk about wanting to spend holidays with family and kids, there may be something to that. But then December 29th rolls around after the holidays and you still don't show up. And December 30th and January 1st and January 3rd, you don't show up. That's the decision you made. Knowing the consequences, that's a decision you made. So there's nothing I can do about it. I'm not going to continue the sentencing to a later day to get a report done because you chose not to. You don't want a report. It's the only thing I can assume. I've been doing this for 22 years, and I've done that all the time when people don't show up. And there's no reason to create some exception in this particular case. So you violate the conditions of your bond. Prison's consistent with the purposes and principles of sentencing. And if you can't show up to the probation for a simple interview, I can't find you're amenable to probation. I mean, that's one of the basic conditions is you have to report to your probation officer, aside from whatever other conditions have to be followed. You can't use drugs. You use drugs. When you turned yourself in, you're positive for cocaine, marijuana, and fentanyl. So you're using this whole time you were out.
I have a drug problem.
So violate the conditions of his bond. Prison's consistent with the purposes and principles of sentencing. Again, the defendant is not amenable to any available community control sanctions. You know, the offense here, it's not just a possession, a drug charge. You stole from people over a 7-month period of time, thousands of dollars. There deserves to be consequences. Therefore, as a sentence to this court that in count 1, defendant serve a term in prison of 9 months. He has credit for 16 days he's already served. I need to advise you upon your release, you could be placed on post-release control for up to 2 years. If you are on post-release control and you violate any of those conditions, the parole authority can return you to prison as punishment for violating their rules for another 4.5 months, the maximum being 50% of the prison term I just imposed. Any additional prison term imposed for violating post-release control is being imposed as part of the sentence at this time. Court disapproves the defendant's placement in a program of shock incarceration, intensive prison program, or transfer to transitional control. Defendant's ordered to pay all costs. Defendant's further ordered to pay restitution to the victims in the amount of $6,006.07 to be reduced by any amount that the victims may receive from insurance proceeds. So I know a claim was made. It hadn't been resolved by the time of the victim impact statement. At a minimum, it'll be a $1,000 deductible, but I'm putting the full amount now, again, to be reduced by whatever amount is received from insurance proceeds. I think that covers everything. Mr. Tapiro, anything else for the record?
No, Your Honor, thank you.
Mr. Fatika?
No, thank you, Your Honor.
All rise.
Good luck. We talked about it, you should write up. You have a week or two.
So what, 9 months?
Yeah, quick credit for 16 days. You got about 8.5 months to do.
I got that name of the guy that passed away. My fiance looked it up. He's in the reign till 2035. Can I give you his name? I don't want to be seen.
Yeah. I talked to the prosecutor. They don't have any documentation of that.
Shannon Hinton. It was in 2023.
All right, good. He just told me that he didn't know. Because he's saying he's up on range, so.
Yeah, but Irish. Shannon.
I think.
Yeah, maybe. All right, I think what we do is we can call down there and be like, hey, this guy's coming. What can we do? Yeah, like, they can do that.
All right.
I'll call somebody, yeah, sure.
Have a good day.
You too, thanks, John. I got the next one.
Oh, me too. Raymond?
Oh, you got that?
Yeah.
Okay, yeah.
I phoned him for you. I think we're gonna stipulate with it.
Yeah, that's what,
So it should be no big.
no, I don't even know what that was. What's our case number, John? I got 2 files here.
I have
400?
23 CR 400.
Okay.